Let's welcome in our next guest. Oh my gosh, it's really quite exciting to know that we are actually live. I love live. Live is my favourite state of affairs with broadcast. Good morning, Michael.
Good morning.
Michael, welcome to Rise with BNT, our first live back. Happy New Year. Well,
Happy New Year tomorrow.
We're not quite there yet. Absolutely. This is so this is New Year's Eve. It is indeed. And Michael, I hope you had a good Christmas.
I did, thank you.
And we appreciate you joining us at this cold and dark morning, but it's lovely to have you. Michael has been with us before, detailing information about miscarriages of justice. And we asked Michael to come back and sort of do a roundup of some of the cases that are just really incredibly disturbing to you, Michael, why they remain sort of outstanding. So where should we start off? Should we start off with Clive Freeman? Because that's how you and I came together in the first place. And Clive's is it's an egregious story, frankly. We actually think that it's highly likely that no crime took place at all. Will you want to tell people about Clive Freeman?
Thank you, Sonia. Good morning.
Good morning.
I think with Clive Freeman's case, I think that the people I work with, we're quite naive, we're quite innocent in a way. We used to think that if you could actually just bring the evidence of errors or the evidence of mistakes to the right authorities in the right way, that the right kind of thing would happen. And we thought that, in a case like Clive Freeman's, some of the regular people who tune into you might know that Clive's now been in prison for 35 years. He's a 78-year-old man with prostate cancer. And if he'd have admitted to the murder of Alex Hardy, he would have done about 14 years. So he's over 20 years past his tariff date, the date he could have got parole. And the thing about Clive is there's now 9 experts have kind of lined up and said that the original forensic pathologist made a mistake. and 2 in particular, there's a guy called Dr. Kohler. And Dr. Kohler said that Dr. Shepherd didn't have enough evidence at his disposal when he made his original, it wasn't his original determination that a murder had taken place. It was on his 3rd autopsy that he changed his mind from his first 2 autopsies where he saw natural causes. And then he saw murder. And it's very suspicious why he changed his mind. But Dr. Kohler says he didn't have enough evidence at his disposal to even determine why Mr. Hardy died at that time. So he seems to have made a decision that it's a murder with no evidence to support that. But more recently, something's happened. The Criminal Cases Review Commission is the body which is charged with looking into alleged wrongful convictions. And it's now had 5 applications from Clive Freeman's team and Clive Freeman. And in the last application, the CCRC refused to actually look at some evidence which further supports Clive Freeman's claim of innocence. And that evidence says it was a guy called Kroll, Professor Kroll in America, and him and a colleague had done some research following the murder of George Floyd by the policeman who kneeled on his neck, okay? And as part of that research that they've done, they were looking into this kind of hypothesis, this kind of theory that somebody could die of asphyxiation by kneeling on their chest, which is what Dr. Shepherd said, now Professor Shepherd, in the original trial. And what they've said is that, and this is new scientific evidence, that says if a person was to use both of their knees and kneel on somebody's chest as hard as they could, that wouldn't even represent 10% of the pressure required to cause asphyxiation. So the CCRC were given that evidence. It came late, which is kind of the reason the CCRC said they would extend time. They would wait for this new report to come in. It came in late. They thought it was being looked at by the CCRC. When the CCRC rejected the case, they said that they didn't look at that evidence. So now another application is going into the CCRC, specifically with that evidence, to make the CCRC consider it. and Clive Freeman remains in prison.
It's shocking, actually, Michael. You have been, I mean, this is not your first time around the block on this. You've been researching wrongful imprisonments for almost quarter of a century now. You are absolutely aware of the harmful consequences of a miscarriage of justice. How bad is our system regarding miscarriages of justice?
Well, I think I'd have to say, I mean, this might sound a little bit contradictory, but I think the criminal justice system in Britain is overall pretty good. Okay, the problem is in any individual case where there's a claim of innocence, we have to take that seriously. So it's not like we get, you know, each year in England and Wales, counting all the summary offences, there's about 1.5 million criminal convictions a year, 1.6 million, something like that. And all of those cases, you know, most of those cases, 99% of those cases or more, they just accept that they did what they've been convicted of and they get on with it. But what we're talking about is, we're talking about mainly historic cases. Clive Freeman's been in prison 35 years, Jeremy Bamber 37 years, Robin Gorbett now 13 years, Ray Gilbert more than 40 years ago he was convicted. But these cases that have got this kind of, they just never go away. And the problem with our system is not that it's wrong all the time. It's that when it's wrong, it doesn't seem to do the right thing and it doesn't seem to know what to do about it.
Right.
So what I would say is just every claim of innocence has to be taken seriously and it has to be looked at from the perspective, is this person telling the truth or not? And what it seems to do, it seems to look at all the cases are looked at from the perspective, did this person have what the criminal justice system thinks is a fair trial? And a fair trial isn't a fair trial as you and I would understand it. Right. Because we would think a fair trial is about searching for the truth and trying to find out, you know, who actually did the murder. But the CCRC and the criminal appeal system, what they're looking for is, you know, did you have an opportunity to make this argument at your trial? Well, in the case of Clive Freeman with Professor Crow's evidence, no, he didn't. That's new evidence. And so the CCRC is a major fault that the CCRC wouldn't look at that case. And it seems to have a difficulty, the CCRC, because it's already refused his case 4 or 5 times, like Jeremy Bamber's already been refused twice. What does the CCRC do? And it's a very sensitive organisation. I mean, I'd just like to say what we found out this year about Jeremy Bamber. Now, Jeremy Bamber is hated by people in this country, including many members of my own family, who just don't want to actually accept the possibility, and I'd say reality, that Jeremy Bamber is innocent.
I hear you.
And the thing about Jeremy Bamber, I spoke before about how there was non-disclosure in that case under a public interest immunity certificate of 347,000 pieces of evidence. But what we found this year, and I don't know what the system's going to do about this. And I was a little bit frightened when we found out about this, because the stuff we're finding out is major stuff, right? So there's a forensic pathologist in that case as well called Peter Venezes. Again, a very celebrated forensic pathologist. And in the case, the defense barrister is cross-examining the forensic pathologist Peter Venezes. And he says to him, so the only wounds on Sheila and Neville and Doreen Bamber, Sheila Caffell, are the gunshot wounds. So there are no other wounds on these people who were killed. They were just sitting there passively while somebody came along and just shot them dead. And Peter Venezes says there are no other injuries on these bodies. Then the judge intervenes. What? There's no evidence at all of a struggle. They didn't try to fight with the person who was trying to shoot them. They just sat there and waited to be shot. Yes, there are no other injuries on those bodies. Well, Bill Robertson has obtained the photographs from the autopsies. And he's found, 37 years on, he's found that there were 70 further injuries, more than 35 on Sheila and more than 35 on the parents, where there's big scratches down the arms, there's scratches on the faces. There's a fight going on to try to stop somebody from murdering them. Now, all of the time this is happening, you know, Jeremy Bamber, he's got no nails. I invite people who are watching this or listening to this to look on CCRC Watch website and read the articles and see the photographs and read the transcript from the actual trial that Bill Robertson is quoting from, which actually shows, no doubt about it, that the expert was lying to the court, and when he said there was no further injuries. Now, that's been submitted to the CCRC, and Jeremy Bamber's been waiting now 2 years for the CCRC to consider this.
Yes.
So, you know, the system for correcting wrongful convictions is going spectacularly wrong, and it needs to be reviewed and it needs to be reformed or replaced. That's what we're saying, because, you know, these cases, you know, need to be overturned, or it needs to be explained why these people did the crimes that they were convicted of. There needs to be a public inquiry into these claims of innocence, and we need to get to the truth of them.
Yes, I think what blows people's minds, Michael, is this idea that, for example, Jeremy Bamber has been inside for almost 40 years. And then we hear that there are these new revelations, new information, and people like, how could that possibly be all those decades on? But it goes back to what you said at the beginning, and that is, we believe that trials are all about the submission of evidence and examining the evidence, but so much is either held back or withdrawn, or, I mean, do you think there are nefarious reasons why this happens?
Well, I think the system doesn't work in the way that we understand it. I mean, we're brought up, I'm writing a book at the moment, and I'm talking about how, part of that book, I'm talking about how, you know, a plot line in most kind of drama series, soap operas, movies that we watch is a possible miscarriage of justice. You know, we're often watching, you know, whether, you know, crime dramas, and there's always this possibility, you know, the jeopardy is the wrong person is going to be convicted for something they didn't do. And it's everywhere. But when we're watching those programs, as soon as the truth comes out, all of the inverted commas right things happen. So the right person is just, you know, automatic. When the truth comes out, the right person is going into prison, and we get our happy ending. But the reality is the criminal justice system doesn't work in that way. The system isn't about searching for the truth of whatever happened. If you think back to the case of the Guildford Four, one of the most notorious miscarriage of justice cases this country's ever seen, when the Guildford Four were in prison innocent, someone from the Poulton Street gang that actually did the Guildford bombings said to the police, they're innocent, we did those bombings. And when the Poulton Street gang were convicted for the bombings that they did, these bombings were omitted from the charge. So they didn't have to admit that they'd convicted innocent people. Those things are intentional. I mean, elsewhere, I mean, I wrote a book some years ago where I made a distinction between miscarriages of justice and abortions of justice. Because there is a miscarriage of justice is language or terminology which is borrowed from medical science. So in medical science, there's an abortion of a fetus, and there's an unintended spontaneous abortion of a fetus. Well, women didn't want what we now know as a miscarriage to be considered in any way part of the language of abortion.
Right.
So spontaneous abortion was not favorable language to women who wanted to have a baby, and they'd had what we now call a miscarriage. So this language was created to distinguish a miscarriage, an unintended failure, from an actual abortion where people choose to terminate. And so when people started to kind of research about miscarriages of justice, or wrongful conviction, should I say, what they did is they borrowed this language. Now, a miscarriage means an unintended failure to reach the desired goal. So we started talking in a language, in a discourse of miscarriage, when we should have actually been talking about abortions. These are not miscarriages of justice.
Right. Wow.
That's
powerful.
Where there's an unintended failure to reach the desired goal, when you hide evidence, torture people, threaten people, get people, drop charges against people to give evidence against innocent people, This is not a miscarriage of justice. This is an abortion of justice from the very, very start of the process.
Wow.
And all of the major cases that we refer to are actually abortions of justice. The Guildford 4, the Birmingham 6, they were abortions of justice. And we've got to start to consider now that the cover-ups and the lengths that they're going to, and, you know, to try to stop these cases from coming to public attention. These cases now have all the hallmarks, not of miscarriages of justice, but of abortions of justice. Now, there are miscarriages of justice because every day in the appeal courts, convictions are being overturned. But it's these cases that for some reason, they don't want to overturn them. Maybe it's the nature of the crime. You know, people in this country, and it's, you need, like what the Birmingham 6 and the Guildford 4 needed. They needed a mass concern. They needed a kind of critical mass of people within the populace.
That's right, the tipping point.
To be concerned about them.
Yeah.
And when you've conditioned a kind of population, I mean, you know, people talk about how we're conditioned into believing certain things by the government. But if you think about the criminal justice system is the tool, the weapon by which we are governed or controlled in this society.
Absolutely.
And we're conditioned to believe.
Completely agree.
That the criminal justice system works to find the truth, and it doesn't. And so what we do is we've got all these different things like the mainstream media, which kind of convinces people that it's about the truth, and we are conditioned to believe that, and we believe that. And what runs alongside that, these people are demonized.
Yes,
so
heavily.
People like Jeremy Bamber are demonized to such an extent that nobody wants to take that leap of faith,
right,
to believe that he might be innocent.
Absolutely. So that's already an obstacle to progress straight away, is the public image that has been visited on these people. So is Robin Garbett an abortion of justice? Robin was convicted of murdering his wife, a fairly famous case, post office, and he just had his third rejection from the CCRC.
Yeah, I mean, we've just got an article which is going to press. I mean, it's funny really, because we've sent the article to Robin for his blessing really. Because this article is focusing specifically on the DNA aspect of this case. And you know, I mean, not many cases which lead to conviction involve DNA. Although we might see DNA in a lot of these TV programs that we watch, you know, I mean, actually, it's a very, very small percentage of cases. I think it's less than 5% of cases. The last time I looked was a few years ago. It was less than 2% of cases. But if we say safely, it's less than 5% of cases where DNA is used, because people are convicted on other things like their confession or eyewitness identification or CCTV and fingerprints and all the usual things. And what's fascinating about this case is that the murder weapon was found 2 days after Diana Garbett was murdered, and it was picked up by a police officer. And a police officer, and this is the point I thought was really interesting. We were going to name the police officer in the article that we're about to go public with. And Robin doesn't want the police officer to be named. And the reason he doesn't want the police officer to be named is because he said, I've been in prison now for 13 years as an innocent person, and I don't want to point the finger at somebody who might be innocent. So all Robin will say is this person needs to be properly investigated.
Very honourable.
Right? But I don't want, well, he's a Christian, he's a Catholic, he believes it wouldn't be the right thing for him to do, to point the finger at somebody else who might be innocent. But he's very supportive of us publishing the article because what happened in this case was every police officer who actually attends a crime scene gives a DNA sample, just in case they contaminate something. And so on this bar, this police officer's DNA was there, and this police officer's DNA was also in the crime scene, even though he is never supposed to have been at the crime scene. He wasn't working on duty at that crime scene. He hasn't been to that crime scene since. And so his DNA is in Diana Garbett's bedroom where she was murdered, and his DNA is on the murder weapon. And when that was put to the CCRC simply said again, you had an opportunity to discuss this in front of the jury. If the jury made a decision after hearing this that you're guilty, we're not going to do anything about it. But the problem with this is, and you know, I've had this debate with many people about juries in this country. People just tend to automatically assume that juries are a good thing because it's us standing in judgment over us. You know, we haven't got arbitrary power and all the rest of it. And I think that when juries were first introduced, there was definitely a need for something to check this, you know, arbitrary power. But where we are now, what I say is this: juries can only make decisions about things that they have in front of them. And when you've got a case like Jeremy Bamber and there's 347,000 documents not disclosed, how can the jury make a decision about that?
Absolutely.
And there's a concept in our legal system, and it's called perverse jury verdicts, right? And a perverse jury verdict, and this really undermines any idea that a jury makes up its decision for itself, because in theory, a jury hears both sides and then it decides what it wants to do. That's the theory of it, right? But the reality is that in all criminal trials, the judge sums up to the jury and directs the jury what it should find. So the jury is independent in the sense that it could disagree with the judge if it wanted to.
Right.
99.9999999% of the time, the jury just simply do go along with the judge's direction. They simply find the way the judge has directed them. So they're not independent in that sense.
Right.
So there are perverse jury verdicts where the jury has been criticized for actually not going along with the judge's direction. There's a case called Owen Oyston, and they say that's a perverse jury verdict because it went against what the judge said. Well, how can it be called perverse if the jury are allowed to do what it wants?
Right, exactly. Michael, I hate to bring this to an end. I hate to, but I want you to come back again. You keep coming back and we really appreciate it, and update us on more cases that are going on. Give us your website address again so people can see what you're up to.
Well, we've got a number of websites. We've got, if you just put into Google, Empowering the Innocent, I mean, that's the kind of umbrella organisation. And within that, we've got two sub-projects at the moment: CCRC Watch, which features articles by people who were rejected by the CCRC, who are still claiming innocence and are plausible claims of innocence. And we've got False Allegations Watch, which is another project that we've set up because there's so many people saying they've been wrongly convicted of sexual offences. So look on those websites as well. Thank you very much.
Everybody, Professor Michael Naughton, thank you for the sterling work you're doing, Michael. Take good care of yourself. Happy New Year.
Happy New Year, Sonia.
Thank you.